Order number 1, communication from the chair.
Now, honorable senators, following the commencement of the process of the proposed removal from office by impeachment of Honorable Abdi Ibrahim Hassan as governor of Isiolo County, the firm of Theory Wasonga, the advocates representing the governor, raised in writing, pursuant to Rule 14 of the third schedule of the Rules of Procedure for hearing and determination of the proposed removal from office by impeachment of a governor, a preliminary objection. In particular, the advocate stated as follows: A, that there was no valid or competent motion for removal by way of impeachment of the governor of Isiolo County that was passed by a resolution of the County Assembly of Isiolo for the following reasons. 1, on 27th of June 2025 and 2nd of July 2025, the High Court of Isiolo vied Isiolo High Court Constitutional Petition number E004 of 2025, Honorable Abdi Ibrahim Hassan versus County Assembly of Isiolo and 2 others, invalidated the proceedings of the County Assembly of 26 June 2025, giving rise to the impunged impeachment, and further declared the resolutions to impeach the governor as null and void and of no legal consequence. In particular, the governor's advocates drew the attention of the Senate to paragraphs 45 and 46 of the court's ruling, which stated as follows, and I quote, "Therefore, it is the finding of this court that the motion dated 18th of June 2025 and debated by the first respondent on 26th of June 2025 was in contravention of the conservatory orders of this court issued on the 25th of June 2025. Hence, the resolution arising therefrom is null and void. Once an act is declared null and void, it is of no legal consequence." 2, as stated, the resolution has evidently been submitted to the Speaker of the Senate. It is thus upon the Senate, once informed of the orders herein, to determine if it will proceed to handle the said resolution, thus abating a blatant disregard of the rule of law or respect the court orders. 3, the law contemplates that impeachment proceedings can only be commenced and or sustained before the Senate upon the passage of a valid resolution by the County Assembly in compliance with the procedure laid down in the law governing the removal of governor from office. However, in this instance, the County Assembly of Isiolo did not sit on the 18th of June 2025 and 26th of June 2025 to table, debate, pass or vote on a motion for removal of the governor from office by way of impeachment. That the purported Hansard reports of 18th June and 26th of June 2025, relied upon and furnished to the Senate by the County Assembly, were forged, concocted, manufactured and engineered at a venue outside the County Assembly chambers, and further that there exist no votes and proceedings, voice transcripts, and video recordings to corroborate the Hansard reports. Council invited the Senate to conduct a preliminary inquiry by way of trial within a trial in limine, with a view to establishing the authenticity of the Hansard reports presented by the County Assembly in support of the impeachment proceedings. That the purported impeachment motion, as presented by the County Assembly of Isiolo, fails to meet the criteria and legal threshold under Article 181 of the Constitution, Section 33 of the County Governments Act, and standing orders of the Isiolo County Assembly and the standing orders of the Senate. That the impeachment motion forwarded by the County Assembly of Isiolo is a sham, null and void, and of no legal consequence to warrant admissibility, interrogation, or any other action of the Senate. Hence, the same should be struck out in limine. In response to the preliminary objection raised by the advocate for the governor, the firm of Alex and Boniface Advocates LLP, advocates for the County Assembly of Isiolo, stated in writing the following: A, that the preliminary objection raised by the governor do not meet the threshold of a pure point of law as established by the time-honored case of Mukisa Biscuit Manufacturing Company Limited versus West End Its Distributors, 1969 EA 696. B, that with regard to the first preliminary objection, The question of court orders that seek to prevent the Senate from fulfilling its constitutional duties has been settled by the Supreme Court of Kenya in Mate and another versus Wambora and another, 2017, KCSE 1, KLR, and the Court of Appeal in Mwangaza versus County Assembly of Meru and another, Council of Governors, Interested Party 2023, KECA 1599, KLR, where the two courts held that courts lack jurisdiction and are forbidden from interfering with the constitutional mandate of county assemblies and the Senate. That on the same question, the Speaker of the Senate recently ruled during the impeachment proceeding the former Deputy President that any injunction interfering with the work of Parliament has no effect on Parliament in the exercise of its constitutional functions. That consequently, the Senate, through the Speaker of the Senate, ought to dismiss the preliminary objection and proceed unabated, unfettered, and unhindered, in line with the established precedents affirmed by both the Supreme Court and the Court of Appeal. That in respect to the second preliminary objection, whether there was a sitting of the County Assembly to table, debate, pass, or vote on the motion for removal of governor from office by way of impeachment, the same is purely a factual and evidential matter that can only be resolved at the full hearing. That the governor's request for preliminary inquiry or trial within a trial is untenable, as it is a misguided attempt to obstruct and derail the proper proceedings of the House, and it is only necessary when the subject matter of the mini trial cannot be established in the full trial. That on the alleged fraud and forgery relating to the Hansard reports, fraud must be specifically pleaded, and particulars of the fraud alleged must be stated on the face of the pleadings. Moreover, considering that the standard of proof of fraud is more than a balance of probability, the allegations can only be established after a full trial. That the second preliminary objection is fatally defective and ought to be disallowed in the best interests of justice. That in respect to the third preliminary objection, whether the impeachment motion meets the criteria and legal threshold under Article 181 of the Constitution, Section 33 of the County Governments Act, and the standing orders of the Isiolo County Assembly, the issue can only be determined once the Senate has interrogated all the facts and evidence in the impeachment motion against the standard of impeachment as laid out by the Supreme Court in Sonko versus County Assembly of Nairobi City and 11 others. And 11 others, 2022 K. ESC 76 KLR. That the third preliminary objection is also fatally defective, as it calls upon the interrogation of the merits of the impeachment motion at a preliminary stage before the Senate has had the opportunity to hear the witnesses and consider the evidence laid by the parties. That the preliminary objections ought to be dismissed and the matter proceeds to a full trial for a determination on the merits. Now, Honorable Senators, counsel for the parties have this morning made oral submissions on the preliminary objections and responses thereto, following which a number of senators, including Senator Aaron Cheriot, Senator Daniel Manzo, Senator Karungo Thangwa, Senator Tomo Jenda, Senator Danson Mungatana, Senator Osotsi, Senator Samson Chirangay, Senator Eno Kombua, Senator Wakili Sigei, Senator Catherine Muma, Senator Alexander Mundigi, Senator Agnes Gavindu, Senator Karen Nyamu, Senator Okiyo Mtata, Senator John Methu, Senator Peris Tobiko, Senator Mwenda Gataya, Senator A.C. Okenyuri sought clarifications on the same. In the clarifications, the senators ought to be informed, among other things, the identity of the clerk of the County Assembly, whether there was a sitting of the County Assembly of Isiolo on the impeachment process, and whether the Hansard recording of the Assembly's proceedings was submitted to the Senate in full and its validity in the proceedings before the Senate. The status of the decision of the High Court to nullify the proceedings of the County Assembly, whether the proceedings of the County Assembly are transmitted or broadcast live, the deployment of security officers at the County Assembly, whether the impeachment motion that was quashed by the High Court is the same motion submitted to the Senate, and its validity for impeachment proceedings against the governor, whether the sittings of the County Assembly were properly convened, whether or not there was a court order issued against the County Assembly on the impeachment process. Subsequently, counsel for the County Assembly gave responses to the questions and clarifications sought by senators by stating inter alia that the governor captured the clerk, and that the County Assembly had evidence in this respect, and that the impeachment process ought to proceed, that the preliminary objections are primarily founded on issues of law, and that the County Assembly had witness statement to counter the allegations made by the governor, that the County Assembly held sittings to impeach the governor, and evidence on the same will be adduced, that the Supreme Court, in case of MATIANG'I, gave guidance in respect to incomplete impeachment proceedings. Likewise, counsel for the governor responded to the issues raised by senators by stating inter alia that with respect to the questions relating to the work, relating to who the clerk of the County Assembly is, the County Assembly's own submissions in Volume 5 and page 8 settled the matter, that there were no sittings of the County Assembly, and that affidavits of the deponents in the proceeding indicated that there were no sitting of the County Assembly, that no appeal has been lodged on the court orders against the County Assembly, and that the motion before the Senate was the same motion declared null and void by the High Court. Arising from the preliminary issues canvassed, the following are the issues that require determination by the Senate. 1. Whether the County Assembly of Isiolo held sittings on the 18th of June 2025 and 26th of June 2025 to table, debate, pass or vote on a motion for a proposed removal from office by impeachment of the governor of Isiolo County. And 2, whether in light of the court orders nullifying the proceedings of the County Assembly of 26th June 2025, the Senate is able to proceed with a hearing on the proposed removal from office by impeachment of the governor of Isiolo County. Honorable Senators, it is not in doubt that the trial court in impeachment matters is the Senate. Accordingly, the preliminary objection raised by the counsel for the governor will be determined by a vote of the Senate. The procedure for proceeding to this vote will be by a motion in the usual manner, preceded by a notice of motion. The vote will be taken upon the conclusion of debate. To this end, I have directed the clerk to prepare and circulate a supplementary order paper containing 2 notices of motion and the respective motions speaking to each of the preliminary issues raised. Honorable Senators, the decision on the proposed removal from office by impeachment of a county governor and any consequential or incidental decision thereto are matters concerning counties, and accordingly, and has been previously ruled, in all the impeachment processes undertaken by the Senate, these decisions are made by the Senate by vote by county delegations. Accordingly, the preliminary issues will be upheld only if supported by the votes of at least 24 delegations. It is clear that if the preliminary issue contesting whether the County Assembly of Isiolo held sittings on the 18th of June 2025 and 26th of June 2025 to table, debate, pass and or vote on the motion for the proposed removal from office by impeachment of the governor of Isiolo County is upheld, this impeachment shall terminate forthwith, and it will not be necessary to proceed on the motion or vote on the second preliminary issue. as doing so will be an academic exercise. If, however, the first preliminary issue is negatived, the Senate will proceed to consider and determine the motion on the preliminary issue relating to the court orders and their effect. It is so directed. Thank you. Next order. Yes, Counsel.
Clarification from you, Mr. Speaker. During the proceedings that took place earlier on today, we as Counsel for the County Assembly understood, Mr. Speaker, as having directed that the members of this House, when they retire, to consider the preliminary objections you have just framed for their consideration, will have the benefit of listening to the audio of the proceedings in question. Mr. Speaker, when my colleagues who I act with for the County Assembly attempted to supply the audio to the Office of the Clerk, the Office of the Clerk was of the view that they did not hear you make the direction in respect of this audio being available for the members of this House to consider, and they asked us to come back to you and ask you to make an express direction to that effect. Mr. Speaker, I am on my feet this evening asking that that direction be made so that the material before members is complete, pursuant to directions that you had made earlier on. Thank you very much.
Honorable Counsel, maybe there was a misunderstanding. My directive was to the effect that while the senators retire to deliberate on this matter, they will also exercise their minds on the two videos that had been played. That was my understanding. That was my understanding. And that's why I upheld and agreed to the request that was made, so that the senators can look at those two videos that had been played.
Mr. Speaker, when Mr. Mawira was on his feet, I believe he asked the question directly, direction that suggested that even the audio should be supplied to the Office of the Clerk for that purpose.
Well, there is certainly no way we can accept further evidence that had not been submitted as part and parcel of your bundle of evidence.
I am guided, Mr. Speaker.
Next order.
Order number 2, notices of motion.
The Senate Majority Leader.
Mr. Speaker, I rise to give notice of the following motion, which is preliminary issues on whether the County Assembly of Isiolo held sittings on the 18th of June 2025 and 26th of June 2025 on the proposed removal from office by way of impeachment of the Honorable Abdi Ibrahim Hassan, Governor of Isiolo County, that whereas pursuant to Article 181 of the Constitution and Section 33 of the County Governments Amendment Act, on Thursday, the 26th of June 2025, the County Assembly of Isiolo approved a motion for the removal from office by impeachment of Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County, and further whereas by letter reference CA RES Volume 1/001 dated 26 June 2025 and received in the office of the Speaker of the Senate on the 27th of June 2025, the Speaker of the County Assembly of Isiolo informed the Speaker of the Senate of the approval of the motion by the County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly, including the list of the 16 out of 18 members of the county assemblies that voted in favor of the removal from office by impeachment of Honorable Abdi Ibrahim Hassan, the Governor of Isiolo County. Noting that a preliminary issue was raised by the Governor of Isiolo County on whether the County of Isiolo held sittings on the 18th of June 2025